And thank you everybody for joining this session. It's great to see so many of you here. Some of you may have attended the subsidy control session that I presented earlier this year. And in that seminar, we were very much looking at an overview of the subsidy control regime. The focus of this event is very much on the application of the new Subsidy Control Act to universities, research organisations and other HEIs, and to talk about some of the changes that have been made to the bill during its passage through Parliament. Subsidy control remains high profile and political. Since I last spoke to you, we've had the first case in the UK courts involving British Sugar under the EU-UK Trade and Cooperation Agreement. There's also been an EU Commission investigation into UK contracts for differences, and there was an alleged subsidy over questions or requirements for local content, which in fact has now been settled. So in terms of topics, I'm going to talk about some of the sort of shift in emphasis from the previous state aid and subsidy control regimes under the Trade and Cooperation Agreement, and highlight some of the changes from the bill to the Act. We're going to give a refresher on what is a subsidy and when it is permitted, and then talk about the focus on research and development. So after the focus on looking at the implications under the Act for Research and Development, there have been quite a few changes to the transparency database and the requirement to publish. We'll talk about some of those thresholds, then look at remedies and enforcement, and I'll try and make some concluding comments on how to manage risk under the new subsidy control regime, and then we'll look at what next. The next slide, when we get there, is to give a reminder of subsidy. Right, so I talked about going back to some of the key changes. The good news is that the subsidy control regime is structured as a much more permissive and flexible regime. So with some exceptions, subsidies will be permitted. That's a change from the previous regime, whereas if you had a subsidy, it was automatically prohibited unless you got it with an exemption. So we'll see when I talk about what is a subsidy that some of the concepts at least are familiar, but the language used is different. Now, one of the requirements under the new regime is for contracting authorities and donor grantee public bodies to carry out a self-assessment against subsidy control principles. Now, these are quite wide. They cover legal and commercial and economic issues. There are a number of categories called subsidies or schemes of interest or particular interest. We'll come on to look at those, and which do require a sort of individual approval. But the good news is that the process will be much quicker than the previous notification system. And for HEIs, we've got a lot more certainty, I think, from the recent guidance that has been published on the Act. One of the issues that we've been struggling with in the last 18 months since we were under the Trade and Cooperation Agreement is that there has been very little guidance, particularly in the HE sector. So that has got to be welcomed. So we've got a sort of a slightly different method of enforcement, which is going to be through judicial review. So just to highlight some of the changes from the bill to the Act, they have mainly been around the thresholds at which you need to notify. There has also been a focus on making sure that levelling up is recognised as an objective under the Act. We've got a lot more detail now on some of the categories of subsidies. So hopefully now going on to the next slide. Right, what is a subsidy? So there are 4 conditions, and as I said, the concept should be familiar. So you have to have a measure which is given directly or indirectly from public resources from a public body. And the indirectly is important because you may have organisations, for example, a catalogue of organisations which aren't directly public bodies, but they pass through funding and they will be caught. So the measure must confer an economic advantage or specifically favour an enterprise in relation to the provision of goods or services. And then you have to have an actual potential impact upon competition or investment within the UK, or trade or investment between UK and a country outside of the UK. Now, what's new is the competition or investment within the UK. So you can have a subsidy which impacts upon the various different parts of the UK. So that's what is a subsidy. Let's look now at what is not a subsidy. So, like the old state aid and interim subsidy control regime, non-economic activities are not caught. So where an organisation is acting, carrying out not acting in a commercial way, then you don't get a subsidy that arises. And that's really important for the HE sector. Again, if you can demonstrate that money that where you're a beneficiary of financial assistance, that you're acting on market terms in the supply of goods or services, for example, or you're investing in a similar way to a commercial operator, that is not caught. Now, some of the specific exemptions under the Act, there's an exemption for large cross-border and international projects. And the guidance that has been issued by BEIS recently recognises that there may be some international projects for research which are exempt. And I suspect they're thinking of schemes such as Horizon there, although we haven't got any further guidance. So importantly, legacy and withdrawal agreement subsidies are outside the scope of the Act. So legacy schemes are schemes that were approved as part of the state aid regime. And I was just trying to think whether there were any that I am aware of. But actually, when I did a search on the database, I did come up with a legacy scheme for UK RI Innovate, Research Development Innovation Scheme. And that's effectively a scheme which is applying the principles of the general block exemption. And so where you had subsidies that were granted under the old state aid regime, they are likely to continue, as are subsidies granted during the transitional period, and they're covered by the Withdrawal Act. Now, there is one NB to note that if there are substantial modifications to those schemes, they may be treated as a new subsidy. There's a new section in the Act on modifications to subsidies. There's quite a special regime for that. We haven't got time to go into details, but I just wanted to flag that. The other exemption is minimal financial assistance, which is the new word for de minimis, and organisations can receive up to 315,000 over a period of 3 years, provided that certain sort of reporting notification requirements are met. So they are treated as an exemption to the rules. They're not completely exempt because there are rules on transparency, which we will come on to. So I thought it would be helpful just to include on the next slide a subsidies checklist. This is just really to explain that if you find yourself in a situation where you are the beneficiary of a subsidy or are likely to be flowing down a subsidy, then these are the questions that you need to ask in carrying out an assessment. So the category of subsidy is really important because there are sort of 3 separate regimes, if you like, for treating subsidies under the Act. Now, the general rule is for baseline subsidies, and that baseline subsidies need to be assessed against the 7 principles, which we'll look at, in order to be permitted. Now, unless the subsidy is able to take the benefit of a streamline route, or the subsidy is of a certain high value or is in sensitive sectors, in which case it's treated as a scheme or subsidy of importance of particular importance, okay? So looking then at the next slide, baseline slides, or baseline subsidies. So under the Act, the responsibility for carrying out the self-assessment against the baseline principles lies with the grantor public authority. But we're seeing, particularly in practice, that beneficiaries will be asked to provide their own subsidy control assessment as to why there isn't an issue under the regime. Something that we saw under the previous regimes, and I think in practice that's likely to continue. Now, I mentioned that BEIS have published some draft guidance, which actually is very helpful. It's rather long, at 200 pages long, and it is still in draft, but it gives some indication of how you go about assessing the 7 principles. Now, my understanding is that I think the intention is that government will produce some examples later on, but we haven't got those yet. So the 7 principles, in order to be permitted a subsidy, must have a public policy objective. Very often that will include market failure or policies such as levelling up or public good in the case of research. A measure must be proportionate, and the guidance says in assessing proportionality you need to look at alternative measures. So, for example, instead of a subsidy, would be providing a loan on commercial rates. Would that achieve the same outcomes? There's a requirement that there is a change as a result of the subsidy, and that the beneficiary should be no better off as a result. We've talked about least distortive means, and there's a there's a reference to making sure that the subsidy minimises the impact on competition and investment within the UK. So again, looking at does the outcome have to be a subsidy, or there are alternative measures that would work? And then there's a balancing exercise to do the benefits outweigh negative effects. Now, the guidance says the analysis, the extent of the analysis required is commensurate with the value and potential distortive effect. So if you have a high value subsidy and there is potential distorting competition, then the level of self-assessment needs to be more extensive. But as I say, it's very difficult to know in the absence of more guidelines how far that needs to go. That is a sort of overview of some of the principles, and I promised that we'd talk. The focus would be on our treatment of research and development. So that is the next slide. So research and development is obviously key to what you do and comes into the assessment in two ways. Firstly, I mentioned that non-economic activity is not caught under the subsidy control regimes. So I'm going to look first at when research and development is treated as a non-commercial activity. And then I'm going to talk about the streamlined route. So previously we've been relying on the Commission Research and Development and Innovation communication, which was very helpful in setting out when universities and research organisations acted economically and when they acted as non-economic activities. Now, the guidance that's been produced by BEIS is helpful. It's not as detailed as the communication. So what the guidance says is that independent and collaborative research and development projects carried out by universities and research organisations will be treated as non-economic. Education and open access teaching, publishing data and research. And then there's also the sort of the extra limb about ancillary economic activities. So the guidance makes clear that where universities are carrying out limited economic activities, and it may be, for example, by way of renting out equipment which has been funded by a subsidy, where that is very limited and necessary to the main purpose of the activity or the organisation, and where it's possible to ring fence the non-economic activity and the economic activity, for example, through separation of accounts, then that will be treated as non-economic activity as well. Now, some of you will be familiar with the 80-20 rule, which was available under the Commission guidance, which said that if 80% of your activities are non-economic and 20% are economic, and provided the costs are the same, you're likely to be treated as non-economic activity. Unfortunately, the guidance doesn't go that far, so there is a slight uncertainty there about what proportion will be treated as ancillary. Types of activity that are commercial, we've talked about renting out equipment, training to businesses for a fee. Those are share or charging a fee for access to facilities or hot desks. Those are things that typically are treated as commercial activities. So if you going through your analysis find that you can't justify your activity as non-economic, how can you get your subsidy permitted under the rules? Well, the answer is you try and get it within a streamlined route. Now, the streamlined subsidy route is familiar in concept, at least, to the old block exemption under the state aid rules. It's low risk in that, provided you comply with the conditions set out in the streamlined route, then the subsidy is deemed to be permitted. Now, the great advantage of using the streamlined route is it's exempt from the higher levels of scrutiny that go with higher value subsidies. However, the disadvantage or the caveat is that if you have a subsidy which benefits from being permitted through the streamlined subsidy route, it is still subject to the transparency requirements, and we'll come on to look at those. I'm going to talk you through the types of activity that are going to be caught by the Research and Development and Innovation streamlined route. Now, I was hoping that by the time I gave this webinar, we would have a bit more information about the streamlined route. It was published in March, and we're still awaiting the final version to be released. So what the draft does is it talks about the categories of research and development that will be contained within the streamlined route, and talks about the conditions. But it doesn't give a lot of the sort of actual finer detail. So the important thing to note is that you're only going to have to use the streamlined route where university or research organisation is carrying out an economic activity. There are four types of category: fundamental research projects, research infrastructures, Rdni projects, and business development. Now, for each of those categories, where eligible costs are incurred as a result of those categories, they will be permitted up to maximum values and subject to intensities, which is a concept that was familiar under the old GBA. And again, the activity must not have started prior to the subsidy being awarded. Now, if I just go through what is covered within the scope of some of those categories. And I think it's helpful that the streamline route makes reference to the TRLs now, instead of the definitions of fundamental, experimental, and innovative research, which was the previous definitions, and they were all quite complicated. It was never clear quite where the boundaries were between one or the other. So fundamental research carried out by somebody in a commercial sense is covered up to TRL 1, 2, 3. Now, of course, if you're a university or research organisation, I can't see that you're going to be doing much of that within the streamline route, because you're going to be relying on it being non-economic activity. However, it is useful to know where, for example, you're flowing down subsidy to project partners, for example. The research infrastructure costs covers facilities, equipment, services, networks and systems which support enterprises and other organisations involved in Rdni in the UK. Now that is an expansion on the research infrastructure definition under the GBA, and I think it's been brought up to date to include networks and systems to cover, for example, test beds and communication technology-based infrastructure. So I think that's very helpful. There is still a requirement for access to be granted on a non-discriminatory basis. Now, you also have research, development and innovation projects, which covers independent and collaborative research and development. Now, I mentioned in the slide about non-economic activities that the guidance wasn't as helpful as the previous European Commission, particularly actually in relation to collaborative research and development. So previously it was clear that CR&D, if it met certain requirements about licensing, then it was treated as a non-economic activity. I think the better approach for certainty would be to treat CR&D under the streamlined route, because it's clearly covered here. It's not so clear that it will be covered for business partners under the non-economic route. There are, however, some criteria for defining Rdni projects. So there are 5 elements which must be met. So the activity must be novel, creative, uncertain in outcomes, systematic and transferable, and/or reproducible. So that's setting it quite tightly. The other area which has been changed quite a lot is in relation to business development for RD and I. Now, where the Streamline route covers business development linked to research, development and innovation, it is very widely drafted. So it covers innovation, advisory, knowledge transfer and technical support services, training for the adoption of innovative processes, identification and development of new markets. It also covers commercialization. I think it is very helpful because it is nice and wide. However, on the next slide, I have identified some issues that come out of my interpretation of the Streamline route as it is. One is that the treatment of innovation hubs and clusters, which was previously covered under the old GBA, there is no equivalent provision under the new streamlined route. Now, a lot of the activities carried out by innovation hubs and clusters will be covered, I think, by the category for business development. But I think that where there is some uncertainty is that the old innovation cluster eligible costs used to cover things like marketing and animation and more business support style services. And it doesn't seem to be intended that business support style services will be covered under the Rdni streamlined services. So that at the moment is one omission. Now, the BASE have said that they are carrying out some further analytical work into the streamlined streams, and it's possible that the groups may be expanded, but we'll need to wait and see. I've highlighted the issue about collaborative research and development and whether partners working with universities are covered, whether they're covered under Streamline route or non-economic activity. Talked about that. as I said, we're awaiting further details regarding the intensities and maximum eligible costs per category. In the next slide, I'm going to try and give you an example of how the Streamline system will work. So, in my case example, I've got a university who wants to set up a new facility to carry out research into improving digital processes in a particular sector. The university wants to work with business partners. So it's successful in obtaining initial funding from a local LEP for a test bed to buy some equipment. So there's a capital aspects and also some revenue for collaborative research and development projects. Now, the university intends to rent out the test bed for commercial use and to provide some training. Now, when you're carrying out a subsidy control assessment, the first thing to think about is who are the beneficiaries. In this case, it would be the universities and its various business partners. There may be other sort of subcontractors involved, but we're going to focus on the university and business partners. So first of all, the question is to what extent some of the activities non-economic, and therefore we don't need to worry about whether there's a subsidy. And I think that's a question that will need to be considered. It's likely that there's going to be a mix of non-economic and economic activities. And the question, therefore, is to what extent is the mix? Is a university able to get it within the ancillary and economic use limb? If not, then the university may need to consider whether its training activities and whether its use of commercial equipment may need to be subject to the streamlined route. Now, the research infrastructure category is clearly going to be very helpful for a university of research organisation if it decides that it's economic for that element of the costs. In terms of the approach for the business enterprises, I think that any fundamental research that the business enterprises carry out, for example, on the testbed, is likely to be within the Streamline route. Collaborative research and development projects with the university also likely to be caught. The question is whether training is likely to be included within the Streamline route, and I think that depends upon the type of training that is going to be offered. If it's only related to the research, it may well be caught, but if it's wider than that, then it's not clear. Of course, it's worth remembering that business enterprises may be able to take advantage of minimum financial assistance. Okay. So, one of the things that I wanted to flag is the importance of relying, I suppose, on the no aid or streamlined approaches. And the reason for that is that the subsidies or schemes of interest or particular interest thresholds are quite low. So if I consider quite a lot of the schemes or subsidies that I've advised universities on, the values can be quite significant, particularly if universities are working in collaboration with a number of partners. And if a university receives a subsidy that is over the thresholds for schemes of interest or particular interest, then that requires another level of scrutiny. So where you have a scheme of interest, then there is a possibility of voluntary referral to the subsidy advice unit for review as to whether the unit considers that the subsidy will comply with the principles. But there will be a much more detailed level of scrutiny and information that will need to be required and provided by the university. Now, if the subsidy or scheme falls within the definition of a scheme of particular interest, then notification is mandatory, and there is a prohibition upon the subsidy being granted until the subsidy advice unit has provided its report and recommendations, and there's been a cooling off period. So the threshold for a subsidy or scheme to be of particular interest is 10 million for non-sensitive sectors and 5 million for sensitive sectors. Now, there's been consultation on what is treated as a sensitive sector, and the government's response includes the following. Aluminium production, manufacture of motor vehicles, manufacture of motorcycles, manufacture of air and spacecraft and related machinery, building of ships. So you can see that the sensitive sectors where trade is likely to be impacted. But given my understanding of the sectors that are involved at UK universities, you can see that subsidies can quite easily be caught under those sensitive sectors or within the threshold for non-sensitive sectors. There's a note there about restructuring subsidies, which is subject to a special regime and also high levels of scrutiny. So looking at the thresholds for schemes of interest where notification is voluntary, that's 5 to 10 million threshold. But if you have a relocation subsidy, whereby the subsidy is dependent upon an activity relocating to a different part of the UK, that will trigger at a much lower threshold of 1 million. And all rescue subsidies are caught as well. Right, so I mentioned at the beginning of my talk that one of the big changes in terms of the passage of the bill through to Act had been in relation to the transparency database. So the thresholds at which subsidies are required to be notified on the transparency database are much lower. The original bill said it was going to be a threshold of 500,000, and the subsidies in assessing the thresholds you need to accumulate. So you can see that that threshold is very easily met. So these are the new requirements. So the requirement falls upon the responsibility of the donor public body, but obviously there will be information that needs to be provided by you as the beneficiary. The time limit for notification is 2 months from the decision to make the award. Now that has been purposely, I understand, left open to some interpretation as to whether it's actually the decision to make the grant or the time when the first payment is actually received. Now, if a subsidy scheme, for example, a scheme by DCMS, has already been notified under the transparency database, then only individual subsidies under it, over £100,000, are required to be notified. But any single subsidies, and I'm thinking particularly subsidies, one-off subsidies by local authorities or LEPs may well be called, all of those now need to be notified. There is no threshold. So that's an important change. Again, if you're relying on minimum financial assistance, anything over 100,000 of that 315,000 allowance needs to be notified. There are also rules upon requirements if there are changes to a subsidy. I've included the details of the subsidy control database. When I looked yesterday, I think there are about 2,500 notifications on there, so it's getting quite busy. We're still waiting for details about how much information is required to be notified under the transparency database. That's the minimum level. I'm just going to move quickly through the sort of enforcement and remedies slides. These haven't changed since the bill. We've spoken about the Subsidy Advice Unit. It's not there as an enforcement body, but to monitor the regime and to provide recommendations, but it does have the power to request information in relation to its functions, and it can impose penalties, quite high penalties actually, starting at 30,000 for failure to comply with information. And if it receives information about a subsidy which it thinks has the potential to distort competition, then it can call in a subsidy even after that subsidy has been granted. Enforcement is by way of judicial review through the Competition Appeals Tribunal. There are time limits for applying for judicial review are very tight, so that's 1 month from publication on the transparency database or following a response to request for information. So once information has been put on the transparency database, an interested party can apply to the public body to find out further information about specifics of a subsidy. And the remedies which are always there of clawback for misuse of funds or subsidies remain. But because we're talking about judicial review, the range of remedies is slightly wider. But it's, of course, when I'm advising on subsidy control risk, it's not just the risk of the subsidy being found to be unlawful. There's the knock-on consequences that apply to universities and research organisations, so suspension, withdrawal or clawback of grant funding, loss of reputation, impact upon other agreements, for example, financial covenants. So just some conclusions on managing subsidy control risk. I think it is really important when you're looking at subsidies under the new regime to try and structure them so that they are either no aid or they're streamlined Rdni scheme, because of the risk that they might be subject to greater scrutiny or because of the additional burden of having to carry out self-assessment. Of course, there may be examples when self-assessment should be required, but obviously that's going to be quite a time-consuming process. As universities, I've mentioned that you've always got to consider the impact and self-assessment route, not only for yourselves, but where you're flowing down and working with other partners to consider the other beneficiaries involved in a project. As I mentioned in the slides, although the responsibility for carrying out the assessment nominally lies with the grant or public authority, I think really it's going to come down to the beneficiaries carrying out the self-assessment evidence and keeping an audit trail of that. I think the point about dealing with publicity and comms is that because the transparency database thresholds have been set so low and they're quite wide, there is going to be a much greater focus on the database, and you may well find that if you are benefiting from lots of subsidies, then that's going to be made public, and you may well receive lots more requests for information as a result of that. So it's an issue about how do you manage with the publicity and comms relating to that aspect. And I suppose linked to the implementation of the Subsidy Control Act, it's making sure that your policies and training is up to date to comply with it. So I suppose the next question, of course, is what happens next? As I say, the Act has got royal assent, so all we're waiting for now is some further guidance on the streamline routes and some of the requirements about what information needs to go on the database and an implementation date. Now, we had originally thought that it was going to be in autumn, but I think probably the expectation now is it's going to be likely towards the end of the year, given the changes in government. But if anybody has any information on that, I'd be very, very interested in receiving that. And we'll keep you up to date as soon as we've got more details on that. So I'm very happy to take questions now, which I'll go and look at. I just want to mention that before the end of the session, I have included a slide. Be very grateful just for feedback, just in understanding how ready you think you are for the implementation of the Subsidy Control Act. But I'm going to perhaps, right, brilliant. It sounds like there's a high level of preparedness, which is very encouraging. Good. Thank you. I hope you found that helpful. And apologies for the technical hitches. I'm going to see if I can access the questions, if there's any questions coming through. If you've got any questions, please do put them in the box. Alternatively, if you want to contact me afterwards, then very happy to answer questions afterwards. Okay, so there's a question here about, in order to qualify as a subsidy, must all 4 conditions be met or just one or more, please? The answer to that is that all of the 4 conditions must be met. So if one of the limbs is not met, for example, you haven't got economic activity, you haven't got a subsidy. That's fairly straightforward. Hopefully question. So what responsibilities fall on the beneficiary of a subsidy? Well, I've talked quite a lot about the fact that that the risk for the beneficiaries of a subsidy is that if it is found to be unlawful, then it could be required to be repaid. There's the possibility that a subsidy scheme could be, or subsidy could be called back by the subsidy advice unit if it's concerned about the way that it's been structured. We've talked about some of the remedies or the risks in terms of the consequential risks of having a subsidy. Those are the other ones. The other responsibility, apologies if I mentioned this, is the fact that actually a lot of the self-assessment is going to fall on the beneficiary. I hope that answers that question.